All the breaches we discussed happen after the time that performance is due. But what happens if before the time that performance is due, one party makes clear to the other that they are not going to perform a contractual obligation? A party can repudiate performance either with words or with actions, and the effect of doing so is tantamount to a total breach. In addition, even silence can constitute a repudiation. Where a party has created grounds for reasonable insecurity about future performance, the party that is rightfully concerned has the option to withhold performance or withhold preparing to perform for a reasonable time, similar to the cure period between material breach and total breach, sort of a cure period for reasonable insecurity. However, after that period has expired, a failure to give reasonable insecurity acts as a repudiation, and a repudiation acts as a breach. It gives a rise to claim for damages, discharges the other party's duties, and allows the other party to cancel the contract. Repudiation, whether by express words, implied by actions, or even committed by silence, functions like a total breach. It gives the other party the right to cancel the contract and sue for damages. We saw an illustration of this in McCloskey v. Minweld. This was an illustration of how an express repudiation must be unequivocal. The quote-unquote repudiation in McCloskey v. Minweld was not unequivocal. In fact, they were asking for help in order to perform, and as a result, it was not a repudiation in that case. We did see an example of repudiation in the classic case of Hester v. De La Tour. Hester v. De La Tour illustrates how unequivocal repudiation acts as a breach. And here we did see an unequivocal repudiation as the person who was meant to take a tour told the porter that was going to take him that he is not going on that tour. Period, full stop. Not interested in performing and not going to pay. Does the porter have to wait around until the date that the tour begins? Or is this, in fact, an anticipatory breach, giving rise to total breach and the ability to sue for damages, cancel the contract, and find substitute performance? Of course it does. This is the classic example of a repudiation. The other party does not have to wait until the time performance is due. The party may even have an affirmative duty to find substitute performance in order to mitigate damages. Under the Uniform Commercial Code, a party may have a statutory right to demand adequate assurances and a statutory right to suspend performance until it receives them. In this sense, the period between demanding reasonable assurances and receiving them is like a cure period, during which time the aggrieved party can withhold but not cancel performance. We saw an illustration of failure to cure reasonable insecurity in the case of Hornell Brewing versus Spry. Hornell Brewing versus Spry illustrates how a failure to provide adequate assurances can function as a repudiation, giving the other party the right to cancel the contract, even though there was no express repudiation or intent not to perform.